A very good morning to you. Thank you so much for watching UBC TV this morning. We come to you live from the Nile Avenue. My name is Julie F. Nantaba. Now, in the current times, we are seeing a mobile court for the very first time in Uganda, or for most Ugandans. And that is a court that's taking place at the premises where the crime was committed under the High Court, being held by the High Court. And the case in conversation is, as we may all very well know, is the case of Okello Onyum Christopher on murder trial versing Uganda. Now, many Ugandans have been disturbed by the suspect's actions in court, for example, asking for water, asking for soda, or even telling court that he is tired. And that one would wonder, with that and the rage that many Ugandans carry, one would indeed wonder if Ugandans actually know how court systems work. That's what we are here to learn today, this morning, with Counsel Arthur Isiko, who is the treasurer of the Uganda Law Society. Be part of the conversation, 0709-602592 by text, WhatsApp, and learn a thing or two, unlearn and relearn at the same time. Good morning, Counsel.
Good morning to you, Julie.
A pleasure always.
A pleasure too. Good morning, Ugandans. My name is Isiko Arthur, the treasurer of Uganda Law Society. For those who are joining in for the first time, Uganda Law Society is a statutory body that is established by an act of parliament. One of its core mandate is to advise government and the public on matters of law. Yes.
Profound. Advise government is very, very key.
Yes.
But in your opinion, I'm glad that we're talking about this because it seems trivial, but at the same time very important, because you realize that many Ugandans actually don't know how courts work.
Sure.
And yet we as citizens, being in the boundaries within Uganda,
True.
at one point we all find ourselves in the courtrooms.
True.
And these things are essential. So let's start with how Uganda's court structures work. How do they exactly operate from local courts up to the Supreme Court?
Yes, for the Ugandan out there, you should understand that in our current government, we have three departments: the executive, legislature, and the judiciary.
Right.
Judiciary is the arm of government that actually ensures that justice is administered. And by administration, we have different courts. One of the courts that we have that most Ugandans know is the Chief Magistrate's Court, because that is the court of first instance. That is the court that actually a Ugandan will go to in case of any challenge. But we also have the High Court, and that is the one which is actually handling the criminal case that you've just talked about.
Right.
Yeah, in case someone has an issue with the lower court, they always go to the High Court. Then we have the Court of Appeal, the Constitutional Court. Constitutional Court has been very famous because of so many cases it comes up with. And one of the cases it handled was that recent case of the computer misuse that actually it annulled. So it is so much common in the ears of the Ugandans. Then we have lastly the Supreme Court.
Right.
The Supreme Court is the final court. All grievances end in the Supreme Court. And recently we had the presidential petition where they had issues concerning the elections. They went to that court. So that is the final court, and it handles all matters to do with the adjudication of matters.
Right.
Yes.
Now, one would wonder if the Chief Magistrate's Court is the initial court.
Yes.
Do we have local council courts, LC village?
Yes, we also have local council courts,
Yes.
just because I didn't talk about them, but
Right.
those are courts that actually handle minor offenses, very, very minor, petty offenses. But serious offenses, where someone will be in prison for a minimum of 20 years, 3 to 20 years, those are matters that are handled by the magistrate's court. And those are they're managed by magistrates. Yes, I hope Ugandans have heard about magistrates. Those are the judicial officers that handle such matters in such cases. Of course, the High Court, it is established by Article 138 of the Constitution of this country. The Constitution for Ugandans out there is the social contract. It is that contract that Ugandans agreed on, that it shall always govern them. And for instance, in Uganda, you have the 1995 Constitution that clearly provides for the role of the High Court. And in matters where people are being charged with capital offenses, for example, we talked about that case of Onyum, who is an accused person. He is being suspected. Most Ugandans normally get annoyed with it that someone was caught in the act. Why do you call him a suspect?
Indeed.
No, our laws are very clear. Unless someone is proven guilty, that person is a suspect until court finds that person guilty. So in the case of Onyum, it is handled by the High Court. And like I've said, the High Court handles matters of a capital nature. Capital nature offenses are offenses where someone can be in prison for life or given a death penalty.
Actually, therein, kindly allow me interject, and let's start from the first court so that we chronologically help our viewer understand the role of these different courts and their chronological flow, case by case, and how someone gets from the magistrate's court all the way to the Supreme Court.
Yes.
Right.
Okay, so first of all, one has to understand that no one just goes to court directly, especially for criminal offenses. We have the civil aspect where it is a party, like an individual against an individual, or an individual against an institution. You have heard about cases of Uganda versus a certain company. Yeah, I mean, a party, let's say Isikwata versus an institution, that is a civil case. But criminal cases are cases against the government. Yeah, the government is taking you on in respect to a certain act or omission that you did in respect to an individual or an entity. So in this case, we are dwelling so much on the criminal aspect since the starting point or the gist of this all is Onyumi's case. Onyumi's case is a criminal offense of killing, allegedly killing infants. So in this case, one has to understand that no one goes to court directly. The first instance or the first institution that handles such matters is the Uganda police. It does the investigations. They investigate the act that was done, the items or weapons that were used. Yeah, they even go an extra step of liaising with the other institutions like hospitals to come up with a post-mortem report to indeed confirm that this person died because of A, B, C, D, or actions that are attributed to the suspect. Like I've said, the suspect is someone who is suspected of having committed a particular offense. So in this case, the first instance is the police, which does the investigation. Then after that, we have the Directorate of Public Prosecutions, the state attorneys. You've heard about state attorneys, the DPPs. Those are people who direct investigation. They advise police that investigate in such and such an angle, looking out for certain ingredients or certain particulars that can enable court actually determine that so-and-so committed a particular offense. So basically, you have the police and we have the Directorate of Public Prosecutions, or those ones we call state attorneys. So those officers ensure that all the evidence is gathered appropriately, and then the file is sanctioned and sent to police. So by sanctioning, it means that you have a case to answer. Yes, you have a case to answer, and therefore they are forwarding your file to court. And by court, the file can be forwarded to a lower court or the court of first instance, like I've said, a magistrate's court. Or for capital offences, it can always be forwarded to the High Court. But the scenario with the capital offences is that before you are forwarded to the High Court, they first arraign you in the magistrate's court, which is the lower court. And by that, basically, they're taking you there so that they can read for you the charges. That you are being accused of having committed murder on such and such a day, but you have no obligation to plead guilty at a lower
whatsoever. If it's a criminal case.
If it is a capital offense.
Capital offense.
Yes, capital offenses, I've said those are cases where you, in case convicted for that offense, you can be sentenced to death or life imprisonment. Right. So with such offenses, they take you there. It's called committal proceedings. Yeah, they forward you to the magistrate's court where you are supposed to listen to the charges, and you have no obligation to say yes or no to such an offense. We call it plea taking. You have no obligation whatsoever to do plea taking. So at that time, once all evidence has been sufficiently gathered and the state says now we are okay to proceed, then they forward you to the High Court, and that is where Onyum currently is. At that court, that is where they start listening into the merits and demerits of the offense. So for the Ugandan out there, you should realize that you don't just go straight to the High Court. At the High Court, that is where you're supposed to take plea. Yes, plea means that you either accept or you refuse the case that has been charged or case brought against you. For example, in this case, we have a case of murder. Basically, you either accept that I committed murder or I didn't.
Right.
It's a simple word, yes or no. Do you plead guilty? You just either say yes,
my lord,
or you say no.
Right.
So in case you say no, that means the state will have an obligation. By state, I mean the government. It will have an obligation to ensure that they bring all evidence to ensure that they pin you for the particular offense that you are being tried. Or for example, in murder, they are supposed to ensure that they bring all the elements. You committed murder, you had the intention to commit the murder, you acted to commit murder. Yes, and by that, that is why Ugandans were really surprised when they had to subject this person to an insanity test to ensure that capacity to commit the offense that he did commit, because there are challenges where someone is being tried of an offense, but he did what he or she did without actually having the mental intention to do so. So with capital offenses, all those issues are supposed to be looked into. The vigorous exercise of ensuring that justice is served, they have to ensure that his mental capacities were working at the time. So basically, with such a court, like I've said, after ensuring that you are mentally safe, you committed the act, understanding what you actually did, then the government has an obligation to ensure that they bring witnesses.
Right.
Yeah, by witnesses I mean people who have to testify to ensure that indeed they bring out all the evidence to confirm that actually you committed a particular offense. But the grand norm or the core principles of justice before such proceedings are taken, one should understand that our constitution envisions a situation where it actually says that every person is presumed innocent until he or she in the act was caught in the act. He was caught at the scene of crime where actually young ones were found. Right. Yeah. In a very sorrow state. So in such a situation, they're wondering, why didn't they just convict this person there and then? All the evidence points to the fact that so and so actually committed the act. But the law is quite clear, and it is so unique that it assumes that you are innocent until evidence is brought to indeed confirm that you actually committed the offense. And also, one should understand that that person as well also has a right to legal
against Uganda, versing Uganda, and Uganda is actually suing because of the degree of the offense. Then at what point do they still have a right to a state lawyer? Yes.
Yes, an accused person has a right to legal representation. If the accused person has the capacity in terms of finances to procure a private lawyer, then they can do so. However, there are challenges where someone has no capacity financial to hire a private lawyer. In such a situation, government will hire, they will bring in a lawyer, we call them state-funded lawyers, and they will ensure that they assist you to represent you in that trial until it is actually completed. So basically, government has an obligation to ensure that they provide for you legal representation, despite the fact that they are the ones trying, who are trying to ensure that actually you are convicted of that offense. They have an obligation to ensure that they give you legal, and also give you the facilities. Right. They have to provide you with the facilities to ensure that at the end of the day, you are able to defend yourself. And by doing so, that's why they say they have to give you a lawyer. They have to ensure that all the facilities that can enable you defend yourself properly, sufficiently are provided and given to you. Of course, the biggest challenge that most people are saying is one, how do we come up with the mobile courts? People are used to going to buildings that are provided for example, here in Kampala we have the criminal division just opposite CPS. That is the mindset of a Ugandan, that court is a building. Court is a place where it has actually been gazetted. It's like a police station. Right. It has been gazetted. Recently, the judiciary came up with a circular, 2026 circular, where it did note that there are places where justice needs to be served, but it is far away from a court of law. Okay. Yeah. For example, I'll give an example of Kalangala. Yeah. Kalangala Islands, a capital offense can be committed there, but you have to come all the way to Kampala to get justice. So sometimes it becomes costly for the litigants or the witnesses. You have to undergo that hassle of being on a boat, traveling up to High Court. So they came up with that principle that they can now take the court to the place where the act was actually committed. For example, in this case, Gaba. The offense was committed in Gaba, and they decided to take the court to. Of course, there are challenges. Uganda society came out saying it shouldn't have been taken to Gaba, it should have been court since it is nearer. But the fact is that the judiciary has a mandate. It has the discretion to ensure that they can actually take the person to a place where they feel justice can actually be delivered. And in this case also, Ugandans will note that the time frame that was given. Ordinarily, cases have been taking so long. You find someone is being charged of a capital offense, and the case takes 2, 3, 1 year.
Right.
Yeah, takes quite a long duration of time. Recently, the principal judge said this is a case that they intended to complete within at least 1 week. Of course, there have been challenges, whether the health status of the accused person that have actually ensured that the 1 week duration is not actually there too. But at least what they're trying to do is to ensure that within a short period of time, justice can be seen to be done. And majority of Ugandans are asking themselves, why isn't this person asking for bail? Yes? Indeed. Why isn't he asking for bail? Or why isn't bail being granted? Yeah? Article 23 of the Constitution of our country says every person, yeah, accused of any offense has a right to apply for bail as long as they fulfill certain conditions provided for under the bail guidelines. And one of them is to ensure they have sufficient sureties, the nature of the offense is always looked into, and then also they look into so many other factors, and one of them is if the matter is probably going to take, for example, if someone has been on remand for more than 6 months. I've heard about that situation where someone is being charged of a capital offense, but they have been on remand for more than 6 months. So they look into all those circumstances. So this case in particular, this person hasn't been in remand for long. I think this is a person who was imprisoned by police after 2 days, then he was taken straight to court. Then the vigorous mechanism of the law started to work. So in such a situation, the obligation is always on the court. It is always on the court, and it is also the obligation of the accused person to apply for it. If the person doesn't apply for bail, then basically a court may not actually look into that application, because court will actually entertain matters as they come to it. Right.
Yes. Now, with that being said, we've been looking at how the High Court works, coming from the magistrates and then into the High Court. At what point does the Court of Appeal come into play for any case?
Yes. Court of Appeal comes into place especially where someone has been actually sentenced, and convicted and sentenced. Yeah, like I said, the High Court process, witnesses are brought, cross-examined by your lawyer. Yeah, the accused person has a lawyer, so they bring witnesses to give evidence against the accused person. So after they have been cross-examined, then cross-examination basically means that your lawyer has to ask those persons questions to indeed confirm that what they're saying is right or wrong. Then you also have an obligation to bring the witnesses, the accused person. Yeah, and also the government has an obligation to ensure that they ask questions to those witnesses to indeed confirm that what they're actually saying is right or wrong. After all that has been done, court makes a judgment, and then it sentences you. For example, you have been sentenced to 10 years imprisonment.
Right.
So after that, an accused person has a right, or the state has a right to appeal a decision of court. So you only go to the Court of Appeal after a decision has been made.
Yeah.
And therefore, whoever is aggrieved, because the aggrieved party can be the government. The court can say that this person is accused, but he didn't commit the offense. So the government becomes aggrieved. Or the government, or the court can say, we hereby convict you for 10 years. We need to confirm that you actually committed the offense. So the aggrieved party has an obligation. He or she has an obligation to go to the Court of Appeal, and you have an obligation to do that within 14 days. Yeah, after judgment has been done, you have an obligation to go to the Court of Appeal to appeal, yeah, the decision of court within a specific period of time, 14 days. Failure of which the window of appeal shall be closed. Of course, there are reasons where probably someone has been, for example, you have not had sufficient facilities to enable your appeal. There are exceptions to that law where someone can even appeal after the provided duration of time. But that aside, it has to be within a specific period of time. And then the Court of Appeal can either look into the merits of your appeal and either agree with you or disagree with you. So that is how the Court of Appeal comes in. The last Court of Appeal is the Supreme Court, because that is the final court. Yeah? After Court of Appeal has made a decision, the Supreme Court can always look into the merits of the law. And basically for the Supreme Court, they try to limit themselves to issues concerning the law. Was there an error in the law? Not the facts. The facts, like I've said, those are, for example, you are found with a knife, you killed a child. Those are facts. But then there is also the law. For example, when they were sentencing you, are they sentencing you in light of the guidelines, the sentencing guidelines provided for by the courts of law?
Interesting. So, because I understand the law works with facts.
Yes.
So now at the Supreme Court, it's based on the law and not the facts.
Yes. Basically, with the Supreme Court or the Court of Appellant, an appellant court, they limit themselves to the law to ensure that whatever they are dealing or whatever they are trying to ascertain, there was an error in the law. Yes.
Interesting. We are understanding how the court system works here in Uganda. Be part of the conversation by sharing your opinion, what you're learning, or the question that you have. 0709602592 by text, WhatsApp, to get into some of the comments. Hi, this is Emma. Emma, thank you so much for being on. What are you learning? Do share. And somebody else comes through and says, Maggie here is watching UBC. Thank you for watching UBC. And Nabiye Fatuma, hello UBC. Thank you, Nabiye, for being on. And Brenda says, thanks for the program. It's this bit of education to the public, to the extent of thinking justice is for the rich, and therefore omwavu tasinga musango. They lack that bit of knowledge on how courts work. Thank you very much. Brenda, thank you for being on the show. And I think this is profound because many times it's all about the knowledge of the law. If you know, it's easier to maneuver than when you're ignorant. Good morning, Uganda. Is there a chance of killing... Is there a chance of killing him publicly after confirming? That's a crime in itself. Oh my goodness, very interesting comments coming through. Now let's look at the jurisdiction. Does jurisdiction affect where a case is heard? I understand, of course, now the court allows, like it is for the case of Gaba, or if a crime has been committed in Kalangala, court might as well take place at the crime scene in Kalangala. But at the end of the day, does the jurisdiction affect where a case is heard?
Yeah, basically jurisdiction is very important. For example, I'll tell you that the High Court has different divisions. And, you know, jurisdiction, one is in terms of the court, the division of the court to handle, but even the particular court. Yeah, for example, we have so many divisions of the High Court. We have the civil division that handles civil matters. We have the criminal division, where currently Onyum is. We have the anti-corruption division. Yeah, we have the land division. We have the family division. All those are jurisdictions. Yeah, that you can't bring a family matter to a criminal court. So the jurisdiction of family matters is the family division. So jurisdiction basically means the right forum in which someone is supposed to take a particular offense. But even in a particular division, there are also semi-jurisdictions. For example, An offence committed at Gaba can't be tried in Jinja. Because Gaba falls within the jurisdiction of Kampala. If you're going by districts. Yeah, so jurisdiction is very, very important. An offence committed in Jinja can't be tried in Kampala. Vis-a-vis all those other districts or places where particular offences are being committed. So jurisdiction is very, very important, and that is why this particular case of Ojum is being tried at Kampala. Though at a specific session, a mobile court session, that is being handled in Gaba. So that is very, very important. The other thing that is very, very important is the independence of the judiciary in adjudicating of such matters. You do realize that there have been a lot of public outcry. Yeah, members of the public are saying, why don't you execute this person openly?
Just as the comments that has come
Then you hear politicians saying, no, this person shouldn't even be taken to courts of law, he should just be hanged there and then. Yeah, so when the judiciary is doing its work, it has to be independent. Yeah, regardless of the public to be independent. Yeah, regardless of the public outcry, regardless of interference. Yeah, from any, regardless of interference, yeah, from any organ of government, it has to be independent. So the judicial officer handling this matter should be able to look at the facts brought to him, and he or she takes a decision without consulting anybody. So that is a very, very important. Yes.
In this case, looking at a mobile court, it's one of the first in Uganda, never seen before for many at least. I don't know if there was any before most of us were born, but at least for the first time, this is quite unique.
Yes.
Do you think this is a precedent that should be followed moving forward? How important is it? How flexible is it? Does it carry a lot of risks that maybe this should be the only one?
Yes, a mobile, it's a good phenomenon. It is something good that has actually been brought forward by court. I think this is intended to ensure that just access to justice can actually be touched by anyone, anywhere. Like I've told you, you have a challenge of courts. Not every place, not every district, or every corner of Uganda has a court and a high court in this particular case. So we find that and a high court in this particular case. So we find that the mobile courts have been brought forward to bridge that gap. I've given you an example, a court in that area, and accessing a high court in Kampala becomes a challenge. So it is a good phenomenon. The only challenge is that it has to be implemented without any interference by any institution. In other words, the judiciary, if it is deciding to take a court somewhere, one, it should ensure there is no interference from any organ of government. One, it should ensure there is no interference from any organ of government. No minister or member of parliament should direct judiciary that please take the court to the scene of crime. Yeah, that shouldn't happen. Number two, there is what we call venue impartiality. Yeah, venue impartiality means that the venue where you're taking the court also matters. If you look at international statutes and covenants, it wouldn't be ideal, yeah, to take a court at the place where the offense was committed, because one, it will have emotional and psychological torture.
Indeed, as we've seen in this case.
Like this case, on the victim, on the suspect, and even probably on the judicial officer. Yeah? There is a way it can actually impair how one would perceive a particular case. So it wouldn't be ideal to take the court where the offense, the scene of crime, taking it to the area, the jurisdiction, for example, Kalangala, and you take it to Kalangala is okay. But now taking it to where the act was done wouldn't be ideal for emotional, psychological, all those can have a bearing on how justice is being administered. But it's a good phenomenon. It's a good phenomenon. It is something that will actually bridge and reduce on the burdens. People have cases, but there is that burden, financial challenge.
Indeed.
Yes, of reaching where court is.
So we are looking or learning or understanding really how the court system works in Uganda. Now, there was a lot of conversation on the internet that the person who was caught the day that case was committed was not Onyum, and the face was different, but at least a picture of Onyum has been shown on the police patrol the day he was arrested, for you to stop having different funny stories on the internet as netizens sometimes come forth. But looking at some of your comments coming through, good morning, Uganda. Okay, I'm Joab from Rukunjiri. I've learned something new in this case. In court, truth is not needed, only evidence is needed. If you don't have evidence, though you have the truth, you cannot win the case. I'm glad you're learning something. Good morning, UBC. Thank you for the program. I'm Emongoluk Moses from Ngora. My question to Council Isiko is, does government hire lawyers from the private sector, or does it have its own attorney generals? Does it hire from the Attorney General's office when it comes to legal representation of unrepresented defendants? Please speak into this one.
Yes, there is a state brief role. Yeah, every year, government invites private lawyers to apply and be put on the state brief role. These are lawyers who, when called upon, will actually handle cases depending from where they are. For example, you might find lawyers who have applied and they're in Gulu, and they're on that state brief role.
Right.
So there is that role. Lawyers, private lawyers have to first apply. Unless you apply, you can never be on that role. So all the private lawyers who apply are put on that list. And it is on that list from where government chooses. In case a suspect has no lawyer, they always choose from that list. And they say they will allocate you so and so to act as your lawyer on such matters. Of course, as Uganda Law Society, we want to improve that law. Why? The question is, who determines which lawyer to represent you as an accused person? Because choice is very important.
Right.
Yeah, who determines that the lawyer to represent you? Number two, since this lawyer is being paid by government, isn't there a possibility that they will actually favor, or they will have, they won't actually do whatever they're doing freely, be independent in their decision making? Those are things that we want to improve, and that is where we called upon government to actually push through the National Legal Aid Bill. Because the National Legal Aid Bill will put aside a separate entity that actually has private lawyers to ensure that they give free legal services to accused persons. It is a separate entity, yes, different from the organs of government. So I believe when such is implemented, that issue, the challenges I've talked about, impartiality, independence, freedom, will actually be solved. Yes.
They are following the guidelines, but people have lost their hope in the government and its system. This, you did not leave your name. I see your WhatsApp name is Planned Kid. All right. Thanks, Council Arthur, for educating us. Thank you, UBC, for bringing in such a knowledgeable council to educate us. Thank you, Council Arthur. This is Waiswa Moses. Thank you, Waiswa, for being on. Good morning. Thank you for the show. But we need justice to those people who were killed, of the children. I think it's what you meant, Oscar. And indeed, we are watching the court proceedings as they unravel. There was one at Luzira Port Bell, a soldier called Bihembo, who killed his wife. All right. If a girl accuses you of impregnating her, and after the baby is born, it happens that you are not responsible for that pregnancy, after you have been imprisoned, does the law allow the girl to be punished? I see a lot of boys are suffering in prison because of the pregnancies they are not responsible for. Speaking to this, Council.
Yes. Criminal cases are cases brought by the government. In this particular case of the lady, she's just a complainant. So in the case of any wrong sentencing or conviction or judgment, you always pursue the government. You have to pursue because the government has an obligation to ensure that before someone is sentenced or what, they bring real evidence. So if the government didn't actually bring substantial evidence and you are convicted wrongfully, then you have to go against the government. And we have cases where people have gone against the government. Every day is billed. Every day that you have spent in prison or incarceration, illegally or wrongfully, the government pays for that day.
That's what they call costs.
Yes, compensation.
Compensation.
The problem is that sometimes our Ugandans, after they get their liberty, they just ignore.
Because they don't know.
Yes,
Most of them don't know.
Some have financial challenges of getting a private lawyer. But the law provides for it. Wrongful imprisonment, you can always be compensated by the government.
Right.
Yes.
Someone comes through and asks, well, they're asking if Okello is facing manslaughter charge or murder charge. But again, anyways, their conclusion as to what they want to learn is what the difference is between manslaughter and murder.
Yes. For the Ugandan out there, I told you, for anyone to be charged of an offense, you have to prove two elements. You have to prove the mental state, that indeed someone had the mental intention to commit the offense. And two, that the person acted using actions to cause death of the person. So once you prove those two elements, the intention, the mental intention, and the act itself, that becomes murder. However, with manslaughter, it means someone didn't have the mental intention. And that is why I talked about insanity, that the government has an obligation to indeed confirm that this person acted when he had the mental ability to understand what he or she was doing. So once you don't have the mental intention, or you don't understand what you are doing at that particular time, then they charge you of manslaughter. So basically, manslaughter, it is the act alone. Yeah. Once you kill someone intentionally or unintentionally, it becomes manslaughter. I mean, sorry, if you kill someone, if you didn't intend, but someone died, yeah, you can do an act. For example, you are moving out of this room and then you knock someone. Yeah, and someone falls and hits his skull on the floor, and that person dies. Yeah, there they can only convict you of manslaughter. You didn't have the intention, but your action has caused the death of a person. But with murder, he had the intention. You leave your home, jump on a border, you go to a certain place, find someone there, and you kill that person. Yeah, that is now, you had the intention. Yes, that becomes murder.
That means your question is answered as to what Onyum is facing. Now, somebody comes through, Brenda, and says it should be also emphasized that the assumed offender or suspect has rights, because public are complaining why Onyum is asking for a break, asking for soda, water, etc. Yet, and to the public, Okello is being pampered, and it's unfair. So I think, yeah, this is something Council also talked about, that a suspect also has rights, just like any Ugandan. The law allows them to have. Good morning, guys. This is a youth chairperson, Lugazi Central Division, Mukisa Pius. Our visitor in the studio said that no minister or MP can make an order in judiciary, but here is in Lugazi court, they remanded a guy on the case of attempted murder without evidence through the orders of the woman MP Buikwe district. So, in Uganda everything is possible? This is someone speaking into a case after what you taught, that no one has to influence. No one has
to direct the judiciary to determine any matter. Whether a minister, whether an MP, no one has that right. Of course, the judiciary always look into the facts brought to it and make a decision. Like I've told you,